The trial court has only relied upon selective evidence led by the prosecution, as already discussed here and above, to pass the impugned judgment and order, which in the considered view of this court cannot be the basis of conviction. The impugned judgment and order of conviction and order imposing sentence are therefore found to be not sustainable and accordingly set aside. The matter is thus remanded back for fresh consideration from the stage of considering of evidence and hearing of the parties. As the parties are represented before this court, they are directed to appear before the learned trial court on 23/6/2025, whereafter the learned trial court shall proceed with the matter as directed herein above in accordance with law and bring the case to its logical conclusion as expeditiously as possible without being influenced by any observation made in this order. It is also provided herein that the appellant is allowed to remain on bail till the disposal of the case as directed herein above on the same terms and conditions that was stipulated by the trial court. Registry shall send back the lower court's records immediately. Yes, any mention?
My Lord, yesterday Lordship was hearing the criminal appeal.
Yes.
My Lord, there is a connected, not connected out of the main accused, my Lord. He had preferred another criminal appeal. The lower court records, the trial court records in that Lordship may like to go through if, my Lord, that
It is
may
not
be
there.
caught. It's not here in this trial court record. It's there in the pending section. So
It's in the?
it's in the pending section, in the criminal section, my Lord.
Okay.
Could it be called, my Lord, today? If Lordship,
See, now that you mentioned about that matter, in fact,
my
can we have it on some other day? I'm having some difficulties.
My Lord,
Today.
my Lord, we can.
When will it be convenient to you?
My Lord will not be sitting this month, I suppose.
This week I am here. Next week I'm here. Thereafter, perhaps roster is like that.
My Lord, next week,
It does not necessarily have to be before me,
my Lord.
Mr. Nair.
His Lordship has heard it, my
But
Lord.
that was briefly, we had basically a prelude of the case.
My Lord,
It can be before anybody. Let us not keep it as part heart.
my Lord. Then could it be on 24th of July, my Lord?
Surely. PP? 24th of July?
Yes.
That matter. Because if it spills over, you keep one day extra.
Yes, my Lord.
That
That's
is better.
right. That's on Thursday, my Lord.
As paid for by the parties, let the matter be listed on 24th of July 2025. It is made clear that matter will not be treated as part heart. Then what is that records you say?
My Lord, of criminal appeal number 2 of 23.
The records of criminal appeal number 2 of 2023.
The trial court records connected with criminal appeal 2.
Okay, please rewrite again. The trial court records connected with criminal appeal number
2 of 23.
2 of 2023 shall be tagged along with this appeal.
My Lord.
Okay.
My Lord. Deep
This is in respect of which item was this?
item number 4 of the hearing list, my Lord.
Item number 4. Okay. Orders in the item number 4. All right.
Deep.
Motion, item 4.
May it please, Your Lordship.
Yes.
Lordship, in this pertains to, my Lord, the land acquisition for the Thwampui helipad, my Lord. My Lord, here we have been paid, there were 2 awards passed. 2 awards, my Lord.
Which place?
The Thwampui helipad, my Lord.
Thwampui. Okay. Thwampui. All right.
My Lord, here, pursuant to orders by Your Lordship, my Lord, initially an award was passed. My Lord, there was thereafter another writ petition filed, pursuant to which a supplementary award was passed. My Lord, in this writ petition, we are concerned with the first award, not the supplementary. It was the supplementary award, my Lord, is a subject of challenge, my Lord, in another writ appeal. Here, on the basis of this award, we were paid initially only the market value of the land. My Lord, I have annexed the actual pay receipts, my Lord, at Annexure 18 from page 115 to 117. Sorry, my Lord, 118 to 123.
This is payment towards
Payment towards market value. If
market value of the land.
Yes, if my Lord sees the heading towards the middle, my Lord, it's market value of land and amount payable. This is the actual pay receipt.
Yes.
This was, my Lord, if my Lord sees the date on the, just beside the signature, it is in March 2022.
Yes. 9th March.
9th March, some 9th March,
some
some
10,
10th,
11,
11,
yes.
in March 22.
Yes.
Thereafter, my Lord, in August 2023, They were paid the solatium and the 12% additional market value. If my lord comes to page 124, that's the actual pay receipt.
August.
August 2023.
August 2023, what was paid? Solatium
Solatium and the, my lord, 12% additional market value.
and interest.
Not interest, my lord. That is why I'm before lordship.
Solatium and addition.
12% additional market value. My lord, that as per as per section 30, my
Is
lord.
that not in the interest?
No, my lord. Interest is under section 80. Interest is 9% and 15%.
12% of the additional market value.
Market value.
This is under what provision?
My lord, section 30.
30.
30.
Okay. And what has not been paid to you?
The interest till now, my lord.
Interest under what?
Under
provision?
section 80. If my, I have extracted section 80 at para 24, page 32, my lord.
22.
24, my lord, page 32. My lord, payment of interest, when amount of such compensation is not paid or deposited on or before taking.
Just a minute,
My-
Mr. Nair. Which page you said?
Page 32, my lord.
32. Yes, please read.
My lord, when the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the date of so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year from on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry.
This is similar to that earlier section.
Earlier, my lord.
What was the section? 34? 54? Oh, what was that?
My lord,
It's paramaterial to the other.
yes, my lord.
Before, no, while taking
34,
possession,
my lord,
if amount is not paid, additional interest are to be paid.
my lord. Section 34, my lord.
34.
34.
Yes, correct. So you're claiming this interest now?
On this. Today it has come for the first time, my lord.
Yes, will issue notice.
My lord.
And Mr. P.D. Nair, learned counsel for the petitioners who submits that the petitioners, by filing this writ petition, are claiming interest payable under section 80 of the right to fair compensation. I'll give the full name, 2013. I'll give you, okay, right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013, act of 2013, bracket. The learned counsel submits that the petitioners were paid market value of the land, of their land which was acquired by the respondent authorities concerned in the month of March 2022. Stop thereafter, the solatium and 12% of the additional market value was paid in the month of August 2022. Stop. However, interest under section 80 has not been paid to them. Stop. Hence the instant writ petition. Stop. He submits that the land of the petitioners are located in Thuampui, helipad area. Next para. In view of above, issue notice of motion returnable by 4 weeks. Ms. Zainab Sangfil and its CGC accepts notice on behalf of respondent numbers
1, 3, 6, and 8.
1, 3, 6, and 8. Stop. Ms. Vanessiami, learned government advocate. Remaining. Learned government advocate accepts notice on behalf of respondent numbers 2, 4, and 5.
7 also. I'm sorry, my lord.
CGC for 7 also.
6 to 7.
Yourself 6 to 7.
Yes, my lord.
Okay, add 7 also. Yes. Then it's complete, isn't it? Any other respondents?
No, my lord.
Since notice is accepted by the learned counsels appearing today, no formal notice is required upon the respondents. petitioners to serve requisite extra copies of the writ petition to the learned. Counsels appearing for the respondents within 2 days, if not already done. It is the matter again after 4 weeks. Respondents to file their counter affidavit in the meantime.
My lord, could I pray for a date? My lord?
All right, then give a date.
Could it also be on 24th?
Okay, it is the matter of 24th. Okay.
July, my
24th of July. Respondents to file their counter affidavit in the meantime.
lord. Deeply.
Item 5.
May I please your lordship?
Yes.
The petitioner herein is an employee under the Mara Autonomous District Council, MADC, at Siaha. He has been working under the MADC since 1989, initially as LDC and thereafter getting promotion from time to time. And on 24/11/2017, he was promoted to the post of superintendent from accountant. And thereafter,
Initial appointment was
on,
accountant,
no, my lord, 1989 as LDC,
LDC, then accountant.
no, my lord, UDC assistant and accountant from
I
time
see.
to time.
LDC, UDC, assistant, then accountant.
Yes, my lord. LDC, UDC,
Accountant is
accountant.
higher than assistant.
I'm sorry, my lord. Initially LDC, then thereafter UDC, and followed by accountant. And thereafter he was promoted to the post of office superintendent on 24/11/2017.
Not assistant.
Not assistant.
Okay. Office superintendent.
Yes, my lord.
Okay.
From accountant to office superintendent.
Okay. Then what is
On
your grievance?
24/11/2017, with retrospective effect from 5/11/2014.
Okay.
However, his promotion was revoked on 2/5/2018, and thereafter it was revalidated on 14/12/2018. And
Yes. Then
thereafter, my lord, on 25/7/2023, the Service Grievance Redressal Committee had made the effective date of his promotion from 24/11/2017, which was also accepted by the petitioner. But thereafter, they have issued the impugn order, that is 28/1/2025, whereby his promotion date was changed to 14/12/2018. And accordingly, the impugn notification, that is 13/2/2025, regarding the final seniority list was published, when he was placed at serial number 8, even though he was already in the senior most amongst them. And the private respondents herein were placed ahead of him, above him, from serial number 1 to 7.
how many private respondents?
7, my lord.
From
And-
respondent numbers
3 to
3 to
9.
9.
Yes, my lord. Here I'm challenging the impugn order dated 28/1/2025, wherein my promotion effective date was made to 14/12/2018.
Page number.
Page number 5050. Annexus 16.
Why do you claim, on what basis do you claim your effective date as 5/11/2014?
That initially, in my promotion order, my lord, on 24/11/2017, when I was promoted to the superintendent, it was made with retrospective effect from 5/11/2014.
Why?
Because I was made to hold the charge of this post since this 5/11/2014.
I see. But that has been withdrawn.
Yes, my lord.
It has been made effective from the date of your promotion.
Yes, my lord. That also I have accepted.
Where's your promotion order?
Page number 39, my lord.
39.
The first one. The first promotion to superintendent. Page number 39, Annexus 7.
This is 24 November
Yes, my lord.
2017.
17. Page number 39.
Okay. This is 24 November 2017.
Yes, my lord.
Then,
Here it was given retrospective effect from 5/11/2014.
later on, now what has happened?
Later on, my lord, the Service Grievance Redressal Committee had made my promotion effective from 24/11/2017, which I also accepted. But I'm aggrieved with the impugn order dated 28/1/2025, which made my promotion effective date to 14/12/2018.
Okay, what is the basis?
The basis was that, amongst other, was that the revalidation order of my promotion was not proper.
Revalidation.
Yes, my lord.
Which one? Which revalidation?
My lord, after I was promoted on 24/11/2017,
Yes.
the same was revoked on 2/5/2018,
Yes.
which is at page 40. And thereafter, it was revalidated on 14/12/2018.
So,
And thereafter, I was functioning as office superintendent with effective from 24/11/2017.
so they say that it should count from the date of revalidation.
Yes, my lord.
I see.
I was already the senior most, and whenever the seniority list was drawn, I
Where
was
is your
placed
seniority
ahead.
list? Where's the seniority list? Page? Have you annexed that?
Yes, my lord.
You said you had serial number 8.
Page number 52. This is the impugn.
You have also impugned this seniority list.
Yes, my lord. If you also may kindly see page number 53. I was placed in serial number 8, while the private respondents were placed from 1 to 7.
Okay.
And despite submitting my representation immediately after this impugned seniority list, the respondent number 1 was promoted by the impugned notification dated 13/5/2025, page number 55.
What happened?
The respondent number 3 was promoted to senior grade. That is the post of under secretary,
53
page 55.
or 55. Who was promoted? Respondent number?
Respondent number 3.
K. Noza.
Yes, my lord.
Okay. You're challenging this also.
Yes, my lord.
So how many things are you challenging?
3 notifications.
This promotion,
Promotion,
then seniority list,
seniority list, and the
then your
promotion of the respondent number 3.
no, that I've already said. Then in notification 13 February. No, this is the final seniority list. Then you're challenging the 28th January.
Yes, my lord.
All right. Will issue notice.
And there are 5 posts of senior grade, that is under secretary in the MIDC. And at present, as per the information received by the petitioner, 1 post is vacant. And if some interim protection may be given pending disposal of the protection.
Senior grade of the
Senior grade is the post of under secretary, under MIDC.
no, what senior grade? Superintendent senior grade.
Yes, my lord.
Office superintendent
Office superintendent.
senior grade.
Yes,
There's
ma'am.
one vacancy.
Yes, my lord.
Where's your statement?
Para
Yep,
31, page
31.
24.
Please write down, heard Mr. Victor L. Rate, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 28/1/2025, by which the date of promotion of the petitioner to the post of office superintendent has been fixed as 14/12/2018. He submits that the petitioner has also challenged the notification dated 13 February 2025, by which the petitioner is placed at serial number 8 of the seniority list. And seniority list full stop, and you can cancel. He also submits that the petitioner has challenged the promotion order of the respondent number 3 issued by notification dated 13 5/2025. So you put the annexures, okay, after each of the thing. The first one was order dated 28/1, correct? Bracket annexure 16. Next was 13 February. This will be annexure 17. The third one was 13 May. This will be annexure 19. Full stop. Next paragraph. The Learned Counsel submits that the petitioner initially was appointed to the post of LDC under the MADC and thereafter promoted to the post of UDC, accountant, and finally as office superintendent. Correct?
Yes, my lord.
Although the petitioner was promoted to the said post with effect from 1/11/2017, the same was rectified
24/11.
to 24/11/1, was rectified to 24/11/2014. Stop subsequently, while the impugn order dated 28/1/2025, his promotion has been fixed as 14/12/2018. Stop. The Learned Counsel submits that the petitioner, in fact, was functioning as office superintendent with effect from 1/11/2017.
24/11, my lord. 24/11.
I'm sorry, with effect from
The functioning as
no,
holding
no,
the church
it's
was
not 24. It's from 5/11.
5/11/2014.
With effect from 5/11/2014. But since actual promotion was given on 24/11/2017, the petitioner does not have any grievance with regard to the date 24/11/2017 as the effective date of his promotion to the post of office superintendent, which was arrived at by that
Service Grievances Redressal Committee.
Service Grievances Redressal Committee. Full stop. However, for reasons not known to the petitioner, the respondents have arbitrarily given the effective date of his promotion as 14/12/2018. Next para. In view of above, issue notice of motion. Returnable by 4 weeks. Government is there? No.
No, my lord. Respondent 1 and 2 are the MADC, but they do not have standing councils.
How will you take steps?
Who registered post?
Petitioner to take steps for service of notice upon the respondents by registered post with ADDU within 3 working days. Next para, having regard to the projection made by the petitioner, it is provided herein that the official respondents shall not fill up the lone vacant post of under secretary without leave of this court. Yes.
Midnight.
Item 6.
Lordship, this is a matter regarding denial of the rental compensation to the petitioner in respect of his land at Pomzol, Pukui, in Lunglei district. And the petitioner had earlier approached this honorable court, and on the basis of the order passed by this honorable court, assessment was made. Lordship, the earlier order is at page 20. The operative portion is that a joint verification committee was constituted, and the joint team so constituted after verification was to make appropriate computation of assessment of rental compensation, and thereafter, Your Lordship, at page 26, the land was surveyed and demarcated on 25 to 27 April 2016. Your Lordship, the land of the
Ramzawa.
petitioner,
Mr. Ramzawa,
Lordship,
only one petitioner now,
yes,
Kedar Siyama.
yes.
Earlier there were 3 petitioners.
Earlier, there are 3 petitioners. Those other 3 petitioners do not fall within this area. Their lands fall outside the occupied area
I see.
after verification.
So direction was given for verification.
Verification.
Then
and
thereafter what happened?
an assessment was made. Your Lordship, the assessment has been made at page 27,
Yes.
and the amount so assessed in respect of the petitioner is 23 lakhs something, and it has been assessed only for the period from 2014 to 2017. And the fact that the petitioner was having his land even prior to his issuance of VC pass by the Pukpui Village Council was can be seen from the allotment made in his favor by the Pukpui Village Council. And since 1966, the land of the petitioner was under occupation of the security
Okay,
force.
this page 28 is an assessment
Yes,
of the land of the petitioner.
yes,
This is regarding rental.
rental only.
This is 2014 to 2017.
Yes,
Then what about the other years?
the other years have not been assessed.
Occupation
Earlier
is
years
from which year?
from 66, June 66. It was under village council pass. That appears to be the region.
Okay.
But the fact that he was having his land allotted by the earlier chief, and that was confirmed by the village council, and thereafter it was continued like that till it was the P-Pata was issued in the year 2010.
10. So assessment should have been made from 2010 then, if that is
At least from 2010, if not 1966.
So what is your claim now?
My claim is that entire area, for the entire period, should have been assessed, and even till date, it continues to be under the occupation.
Okay,
And-
then why didn't you come to the court after that? Your first writ petition was 2012,
12, yes,
disposed of in 2012.
yes.
Then
Assessment
assessment
made
was made in 2019,
19,
and you're filing a second writ petition 2025.
yes, yes. Your Lordship, I had submitted representation even prior to filing of this writ petition at page 29, praying for reassessment. And since the land of the petitioner has been utilized for the purpose of helipad,
29.
yes, page 29.
This also in 2022.
2022, yes. Lordship, during those days of COVID, the petitioner was immobile and he was not in a position to move the authorities. And in 22, he had submitted this application, representation, and even thereafter, nothing was in progress. And
So
the
what-
land of the petitioner having been used as a helipad for a number of years, it appears that they are not, they are requiring it as, on permanent basis. But that is a matter to be decided by the respondents. But till date, it is under the occupation.
Okay, this petitioner, has he approached this court by filing any other writ petition?
2012. No.
No, apart from that. That is disposed of already. No, I have noticed there are some other cases also.
Yes,
That Pukui, all this Komzol area.
Even here in the writ petition,
Is he not a party to those cases?
he was not a party.
But he says that helipad area is land.
Yes.
So I think he should be there.
Uh,
Ms. Zaram Sankui, can you find out?
Not, as far as my knowledge is concerned, in Contempt 7 2012, filed by Kedar Chona, the name of the petitioner may be there, but I'm not very sure because I'm not now a counsel for that. SCKL handled the matter as on today.
SCKL. Which matter?
Contempt 7,
Contempt.
yes.
Okay. But no, you're handling writ petitions also, isn't it? There are some, I think there are some other writ petitions pending also. I think one belongs to Mr. Nair also. That either you acquire it or you vacate it. Item 7 today. And you say that we're going to acquire it. Then some social impact assessment is to be done and all that. So all this bunch of cases, it appears to be quite similar. I don't know whether that's why I'm asking.
I think this present writ petitioner is not, the petitioner there,
I see.
because he was contacted earlier and he was simply waiting for the outcome of this assessment.
Okay.
He was waiting for the assessment to be finally paid. And then since it was not paid, he had approached the authorities concerned, and then now, having no other alternative, he's approaching this honorable.
Okay, Mr. Ramzawa. So petitioner is claiming rental compensation from 1966 till date.
66 till.
And minus the period of 2014 to 2017.
No, even this, for this period, he has not been paid.
He has not been paid.
He has not been
But
paid.
assessment is here,
Yes, assessment is there, yes.
not paid.
Not paid. And by way of an interim relief, if he is allowed to be given, at least for the period of assessment, the period, for which it was assessed.
That is why I was asking you, what took you so long to come to the court? Assessment happened in 2019. COVID is over by 2020, 21. You cannot say that because of COVID I could not come out. 23, 22, 23,
That's
24,
why
25.
He had submitted his representation into.
He's been sleeping. Rip Van Winkle. Suddenly got up and said, today let me claim the rental compensation. He should have come earlier. Anyway, we'll issue notice at this stage only. And let them also check up whether this plot of land, all these things are all
Yes, my
included in some other cases. Because there should not be two separate orders like that. Heard Mr. Sheila Ramzawa, Lawyer Senior Counsel, assisted by Mr. Stephen Lalbotsaya. For the petitioner who submits that this is the second time the petitioner has come before this court. Full stop. The petitioner earlier filed WPC number 47 of 2012 claiming rental compensation for occupation of his land by the security forces. Stop. The writ petition was disposed of by order dated 19/11/2012. by constituting a verification team to verify the actual area of occupation of the land of the petitioner. It was further directed that if the land of the petitioner was indeed occupied, petitioner should be paid appropriate compensation. Oblique rental compensation. Pursuant thereto, it was found that the land of the petitioner was indeed occupied by the security forces, and an assessment of rental compensation was made for the period with effect from 27/10/2014 to 31/12/2017 for a sum of rupees 23,06,819. However, despite the assessment, since no compensation was paid to the petitioner submitted a representation before the Secretary to the Government of Mizoram Revenue Department. Respondent number 7 on 25/11/2022. However, as no response has been made, the petition is before this court. Next para, in view of above, issue notice, a motion returnable by 4 weeks. Ms. Adam Sangpui, learned CGC, accepts notice on behalf of respondent numbers
1 to 5.
1 to 5. While Ms. Vanessiami, learned government advocate, accepts notice on behalf of respondent numbers 6 to 9. Petitioner to serve requisite copies of the writ petition to the learned counsels appearing for respondents today, if not already done. List the matter again after 4 weeks. Respondents to file their counter affidavit in the meantime. Pendency of the writ petition will not preclude the respondents from paying the rental compensation as already assessed to the petitioner.
Lords,
Yes.
Orders, item 12.
My lord, in IA number 178 of 2014, there is an application leave. There is an application for leave to file a third-party appeal. I have filed my objection.
170.
178, IA 178 of 2024.
And what about this condonation?
Condonation, my lord, I am yet to file my objection.
Condonation for what?
Delay in filing the connected IA 170.
Leave.
Yes,
Main thing is leave was filed, but there's
Yes.
some delay.
yes.
Your Lordship,
What is the limitation for filing leave?
204 days. In the last occasion,
How do you compute that?
You know.
You file a leave for filing a third party appeal.
yes, IA is there,
Okay.
but
So appeal is against which judgment? Passed by?
civil judge.
Civil judge.
Civil judge.
Okay.
Senior Division 3.
Okay.
Dated 25/9/2023. Civil
Okay.
suit number 40 of 2023.
And there's a delay of
204 days.
304.
Yes.
So what are we to consider today?
Your Lordship, in the last occasion, in last court date, the learned respondent was directed to file objection in the condonation application.
Oh, you have filed the objection now. Have you filed objection?
In the
Condonation?
No, my lord. I am yet to file my objection. However, my lord, I am.
Your Lordship,
we are
have you
under
filed?
the,
this is the sixth time it has been listed, this case.
my lord, we are under the impression
Ah.
that the application for leave to file a third-party appeal will be taken up prior to taking up a condonation
Mr.
application.
Malhotra, which should be taken up first? There's a third party appeal, but there's some delay. So whether the delay should first be taken up for the leave to file third party appeal, or first you consider the leave to file appeal, then you condone.
The condonation of delay application is for condoning delay in
Filing the leave.
leave to appeal.
Yes.
Then
Lordship.
that will
Condonation have to
Filing-
take it
filing
up
the
first.
appeal, yeah.
yeah, so that will have to come up first then.
So after allowing the leave, so for instance, what is the fun in considering the condonation of delay then, when leave is already granted? So obviously it has to be the delay condonation.
Well, after the leave to appeal is allowed, then only can the RFA be taken up. But if there's some delay in filing the leave to appeal, then this condonation of delay application is for seeking condonation of delay in filing the leave to appeal.
Is it?
Condonation for filing the appeal against the order dated 25/9,
Condonation for filing the appeal,
RFA, yeah.
not the leave.
not the leave.
But then still,
IA, Your Lordship, I have this assumption that IA condonation application is numbered as IA 177 of 2024. And leave to file appeal is numbered as IA 178, 2024. So in my humble assumption, that condonation has to come first, as it is numbered as 177.
If your lordship could kindly come to IA number 178, at page number 4, in the prayer portion, they have written that in the fact and circumstances noted above, it is earnestly praised to admit this application and pleased to grant the applicant leave of the court for filing appeal. So, my lord, condonation is for filing leave to appeal.
For filing appeal.
This is their prayer, my lord.
so let us not get confused with all these things. You see, there is no separate prescription
Yes.
that this many days, within 30 days, for example, or within 60 days, you have to file the application for filing leave to file appeal. There's no such prescription. Delay, I mean, the limitation is in respect of the appeal only. Leave you can file any time. Is there any such kind of
Since
prescribed dates,
My lord-
prescribed time
My
period?
lord, in their prayer, since they have prayed that the application may be condonation may be allowed for filing the for preferring the leave, my lord. That is why we're under the impression that the leave application will have to be taken up first. So accordingly, we have filed our objection to the application for leave, my lord.
You do one thing, you file objection to the condonation also,
My lord,
so that we take it up together then.
my lord, my lord.
When will you file?
Within 2 weeks, my lord.
See, you see the numbering also.
Yes, my lord.
Condonation is 177.
Yes.
Leave is 178.
Yes.
So, why do you require 2 weeks time to file it?
My lord, then after 1 week.
Yes, 1 week.
Yes, ma'am.
As paid for by Mr. Tilal Zekima, learned counsel for the applicant. A week's time is granted for filing objection to the condonation application. All right.
Duly obliged.
Admission items 7 and 8.
My lord, in item 7, we have issued a preliminary notification on 27 May 2025.
Yes,
My lord,
you were saying?
We have issued a preliminary notification
Okay. Written notification for what?
for acquiring.
Acquiring the land.
Yes, my lord.
I've just been served a copy by Miss Linda.
And we have exempted the social impact assessment also. It has been approved by the Honorable Minister.
So,
My lord, could it, I'll obtain my instructions on this, my lord, because in the other cases I have seen that even after issuing the preliminary notification, it doesn't progress. So if the writ petition is kept pending for some time, my lord.
Same date?
My lord, could it be on 25th of July, my lord?
Please write down. Parties are represented by the respective counsels. Stop at the outset. Ms. Linda L. Fumble, Learned Additional Advocate General, submits that a preliminary notification has been issued by the state government in the Land Revenue and Settlement Department for acquiring 20 acres of land at Lungle for settlement of Assam Rifles with Comzol, Lungle. On 27, Lungle. In support of our submission, she has produced the preliminary notification dated 27/5/2025. Stop, Mr. P.D. Nair, Learned Counsel for the petitioner, submits that he may be given some time to obtain instructions from his client. Considering the submissions made, let the matter be listed again on 25th of July. Stop, pendency of the writ petition shall not bar the respondents to proceed with the acquisition of the land in question. The preliminary notification 27/5/2025 produced by Learned Additional AG is shall be retained in record and marked as X for ratification.
Deeply obliged. This is one matter which pertains to Comzol, my lord. Lordship
Comzol.
has inquired.
How
That
many
is the-
people are there, landowners? It's a big parcel of land, I think,
My lord,
20 acres.
my lord, 15 and 621, my lord.
Sorry,
15, my lord, in WPC 7 of 19, 15 petitioners. And in WPC 29, it's 6. So 21 petitioners.
okay. This is item number 5, 6, item number 6 today.
My lord,
There's one single individual.
my lord,
Perhaps you might also be there.
my lord. I'll have to check up.
Comzol will be that helipad area only.
Helipad, my lord. Assam Rifles.
Assam Rifles. All right.
Deeply obliged.
Item 9.
My lord, in this matter, my lord, I was supposed to obtain some instructions, my lord. But I have requested my clients to obtain some documents under the RTI. My lord, till now we have not got it. My lord,
You want some more time?
my lord.
Okay. Mr. P.D. Nair, Learned Counsel for the petitioner, submits that certain documents have been sought to be procured to RDI, and petitioners are awaiting the same. So he therefore submits that matter may be adjourned for
25th July.
he therefore submits that the petitioner may be given some more time. Okay, in view of above, and as paid for list of matter on 25th of July.
My lord. Deeply.
Item 10.
Your lordship, indulgence, your lordship. If this matter may kindly come up Monday. I have a personal difficulty today.
Okay, list again on Monday, as paid for by Mr. A. Malhotra, Learned Counsel for the respondent, and not objected to by the other side.
Item 11.
Similar prayer, your lordship, if this matter can come up after a week. Your lordship.
Okay, what is this criminal petition otherwise?
This is a matter where, your lordship, the petitioner, he has been charge sheeted in a case where he had accidentally run over one person on the 31st of December.
then?
And a criminal case was registered and charge sheet has been filed. Trial is pending, but in the meantime, they have compromised with the complainant, father of the deceased. And the sister of the deceased had also filed a MACT case, which has also already been compromised. So
But
this,
is it compoundable?
it is not compoundable, Your Honor, but the Honorable High Court has power under 482 to quash the proceedings.
On what ground?
In certain cases, Your Honor,
On
where-
what ground? Because of agreement?
Yes, because of the agreement.
Anyway. Okay, as paid for Mr. A.R. Malhotra, learned counsel for the petitioner, matter stands adjourned for a week.
I won't budge.
Any more matters? That's all. You send the judgment, I'll have to give the signature. Judgment on page, no side.